This is something that came up when looking for an Article 262. There's a part of attorneys that are assigned to adults. There's a section for respondents that are entitled to an attorney pursuant to Article 10C, and there's different times. So just before we start that, I just want to go back to some definitions so everybody knows like what we're talking about, because when I first read this, didn't understand it until I knew the definitions of some stuff that was in the definitions. So a caretaker is, and this will make sense after I read this, and then it'll make more sense after I read the definitions and then go into everything. So a caretaker in 10C, destitute child, is a person other than the parent of the child alleged or adjudicated to be destitute who possesses a valid current court order with temporary or permanent guardianship or temporary or permanent custody. So a caretaker actually has guardianship or custody of the alleged or adjudicated destitute child. Now, an interested adult is someone who's over the age of 18, not a parent or a caretaker, who at the relevant time resided with and had responsibility for the day-to-day care of the child alleged or adjudicated to be a destitute child. So here's what it says in 262. In 10C, for an attorney for the adult is assigned to the respondent in 10C, where the parent or caretaker is as defined in 1092, which is what I just read. So the parent or the caretaker can be assigned an attorney to an interested adult as defined in 1092, provided that, so the interested adult is the one that I read, is a person over 18, not a parent or caretaker, who at the relevant time resided with and had responsibility for the day-to-day care of the child alleged or adjudicated to be destitute. And they can get an attorney provided that, and then there's two different factors. A, the child alleged destitute was removed from the care of the interested adult. Or B, the child resides with the interested adult. So an interested adult in Article C can get an attorney if A, the child alleged destitute was removed from the care of the interested adult, and B, the child resides with the interested adult. Okay, now 3, any interested adult as per 1092 or the person made a party pursuant to 1094 for whom the court orders counsel appointed pursuant to 1094. Now 1094 says that the court shall appoint an attorney to represent. So 1094 sub D. The court may, if it deems appropriate, assign counsel to an interested adult or other person named as a party pursuant to C of this section if they can't financially obtain an attorney. Now C says, C of that section says that the court may, on its own motion or motion of any person, deem a person not named in a petition who has a significant connection to the child alleged to be destitute a party to the proceeding if the person consents to being added a party, and such action is appropriate under the circumstance. So if that happens, then the court may, if it deems appropriate, assign counsel to the interested adult or other person named as a party and assign them counsel if they can't financially obtain an attorney.